Good morning. Good morning, everybody. Please don't forget to like the live as you come in. Hold on.
It is our distinct honor to welcome the Supreme Court justices to our community. Each year, we are privileged to have the justices administer professionalism oaths, serve on our advisory boards, speak to student organizations, and now hold court at our institution. The College of Law's mission is to promote an innovative, equitable, and inclusive vision of the law through high-quality, accessible education, impactful research, and service to our communities. The opportunity to witness oral arguments in our space elevates what we teach in the classroom to see advocacy in this profession that we value, and that is the foundation of this republic. Thank you so much to the Supreme Court staff and to the attorneys and their teams for providing an incredible experience in service of our mission and making this day, November 5th, more eventful than anticipated. Thank you again, and I'll now turn it over to Chief Justice Boggs.
Well, thank you and good morning, everyone. We're honored to be with you. Interim Dean Anderson, thank you for the warm welcome and for hosting us today at the College of Law. I'd also like to thank members of the GSU planning team who worked hard behind the scenes to set up this special session. There's a lot of work that goes into this, as you might imagine. So I'd like to thank Associate Dean Tamika Lester, Christine Thomas, Travis Chambers, Natasha Peters, Jaja Franklin, Emily Harden, and Sergeant Wes Patton and the GSU Police Department. Thank you all for what you've done to accommodate us here today. In addition, I want to acknowledge and thank all of the professors, administrators, staff, and students who are here this morning to observe the work of their Supreme Court. We always look forward to holding these special sessions off-site at different locations around the state, including at law schools, outside of our courtroom, and really in hopes that today's session will provide an opportunity for you all and others that are unable to maybe get to the Supreme Court building to better understand the work that we do. While this is not our court's first time at Georgia State's College of Law, it is the first time for many of us on the current bench. I believe that the last time our court was here for oral arguments was in 2016, shortly after this building opened. And I have to mention how heartening it is to see the faces of so many people who are keenly interested in being a part of and hopefully improving the practice of law here in Georgia. I'm now, as tradition is when we go off site, going to briefly introduce my colleagues up here on the bench. I'm going to do this in seniority order. And so I begin with presiding Justice Nels Peterson to my right. Justice Peterson has a BS in political science from Kennesaw State, was very proud of the Owls' recent win over Liberty. Was also SGA president at Kennesaw State. He went to law school and graduated with a JD from Harvard Law School, formerly served as executive counsel to Governor Sonny Perdue, was the state's first Solicitor General in the Attorney General's office, served with me and others on the Georgia Court of Appeals, and is from Cobb County. So that's Justice Peterson. Next to my left, Justice Sarah Warren, who is a Duke University undergrad in public policy and Spanish major, and also Duke magna cum laude School of Law. Double Duke is what I think they're called, which doesn't make any sense to me. She was served as Deputy Press Secretary for the White House Office of Management and Budget. She was in private practice at Kirkland and Ellis in DC, was the state's third Solicitor General in the Attorney General's office, and she and her family live here in Atlanta. So welcome to Justice Warren. Next, Justice Charlie Bethel, a double dog, business degree and law degrees, both from the University of Georgia, former state senator from Dalton. He and I served together in the legislature. He also served on the Court of Appeals, and he and his family live in Dalton, which is in Whitfield County, just north of here in North Georgia. So that's Justice Bethel. Next to my left is Justice John Ellington, another double dog with accounting degree and law degrees from the University of Georgia. He served in multiple levels of state court, serving both on the Court of, or all on the Court of Appeals, and by designation on the Superior Court of the 5 judicial circuits throughout South Georgia. He also served as a municipal court judge in Soperton. He's from Soperton, as an avid, I should say, dog fan, also a turkey hunter, somewhat of a Renaissance man, bakes pies, makes ice cream, and has a green thumb. So, Justice Carla Wong McMillan to my right and your left earned her JD from UGA and her bachelor's degree in history and economics from Duke. She's the first Asian Pacific American appointed to our court. Previously, she and I and others served on the Georgia Court of Appeals together, and she's formerly also a trial court judge, having served as a state court judge in Fayette County. She was born and raised in Augusta, but resides with her family in Fayette County. Justice McMillan. Next, to my left and your right, one of your own, Justice Sean Ellen LaGrua, who graduated from here with her JD and undergrad from University of Georgia. Previously served as Inspector General for the Georgia Secretary of State. She served as Solicitor General, prosecutor for DeKalb County. Before joining the Supreme Court, she was a Superior Court judge here in the Atlanta Judicial Circuit. I know you're all proud, as we are, to come back to her alma mater and be at her school where she graduated from law school. So welcome to Justice LaGrua. Next to my right and to your left at the end of the bench is Justice Berta Colvin. Justice Colvin is a UGA Law and a Sweetbriar College undergrad. She is a former Assistant United States Attorney in the Middle District of Georgia. Before that, she was Assistant Solicitor in Athens, Clarke County. Before that, after that, she served as a Superior Court judge in the Macon Judicial Circuit. She likewise served on Georgia's Intermediate Appellate Court, the Georgia Court of Appeals, and she and her family live in Macon, Georgia. Justice Colvin. Next, to your right and my left, Justice Andrew Pinson, the newest member of our court. He's our third double dog. He has a finance degree and law degree from the University of Georgia. Previously, he likewise served as a Solicitor General, just like Justices Peterson and Warren at the Georgia Attorney General's office. He likewise served on Georgia's Intermediate Appellate Court on the Georgia Court of Appeals. He was born in DeKalb County, and he moved to nearby, about an hour northwest, Lincoln County during middle school. And we enjoy Justice Pinson's service on this court, and I know you want to welcome him as well. So that's Justice Pinson. Finally, myself. I have an undergraduate degree from Georgia Southern and with a degree in political science and psychology. I played football at Georgia Tech for a moment on scholarship until being injured. I have a JD degree from Mercer University School of Law. I formerly served in the legislature, formerly served as a Superior Court judge in the 6 counties of the Waycross Judicial Circuit. After that, I was on the Georgia Court of Appeals for a while and then continued my appellate service on this court. I'm from Ware County, which is Waycross, Georgia. Many of you don't know where that is, 250 miles south of here. You would think you would be in Florida, but you would be wrong. You would still be in Georgia.
I'm pausing him just to say, y'all, that juror said, free me, okay? Free me. Free me, free me. And I just think it's so crazy. I'm going to start it back, y'all, when he starts talking. But I think it is so crazy. Did y'all see how Paige was really like, he didn't say that. Ma'am, he damn sure is saying he can't be unbiased anymore. He is saying that, Paige. That man said, get me off this case. Let me tell you what I think happened. King Slime is not in the courtroom anymore. He knows King Slime gone home. So basically he's saying all this BS y'all done fed us for over a year. And y'all let that man go home. Man, get me off this jury. Get me off the jury, y'all. Jim, get me off the jury, y'all. We gonna go back.
Madam Clerk. All right.
Okay, y'all.
Carolyn DeWint,
We gonna go back.
Robert Noen, Brianna Kabrika, and Rachel Lee.
Good morning. If y'all will stretch out right here in front of the bench so we can get a good look at you. Don't be nervous. Some of the lawyers might be, but you don't need to be nervous. Welcome. It's my honor to administer the oath to you. If you will all please raise your right hand and listen to this oath. You do solemnly swear or affirm that you will conduct yourself as an attorney or counselor of this court, truly and honestly, justly and uprightly, and according to law, and that you will support the Constitution of the state of Georgia and the Constitution of the United States. So help you God. If you agree with that oath, please say I do. And you can put your hands down. It's a tradition at our court that we admit new lawyers to practice before the Supreme Court of Georgia. One of our members gives welcoming comments. You would not be surprised to know who that's going to be today. It is not me or the rest of my colleagues to my right, but rather a Georgia State University College of Law graduate and my colleague, Justice Sean LaGrua. So Justice LaGrua, I'll turn it over to you at this time.
Thank you, Chief, for that opportunity. Good morning, everyone. And Dean Anderson and the rest of the Georgia State family, thank you so much for having us here this morning. It's an honor for me to give opening remarks here at the law school that I attended, sort of. It didn't look anything like this when I and my classmate, colleague, and very dear friend, Judge Joe Burford, attended law school. We were in the Urban Life building with 3 classrooms, no cafeteria, and it wasn't nearly as clean and as pretty. I was trying to think about what to say this morning, and knowing it would be election day made me think I would be remiss not to recognize that. Today is a historic day for you and the country, though I really think every election day is a historic day. It is the day that our collective voices choose how we will be governed. George W. Bush said, "We vote not because we're liberal or conservative, but because we're American citizens, and that's our responsibility." As lawyers, you are the ultimate embodiment of civil discourse that unfortunately has been lacking often in our country as of late. I remember having 2 conversations shortly after I came to this bench with 2 friends and colleagues and lawyers that at the time I did not know knew each other. Both had served in the legislature. We were discussing the fact that there was a time where we could respectfully disagree with one another and not be viewed.
Okay, I'm gonna pause her. She's still, we can see she's still talking. Y'all, when I tell you, y'all in the comments saying, "Hey, did you see this, see that?" I have 1, 2, 3, 4 videos that are still uploading to TikTok. I'm not sure what they have against me at the moment. Do y'all think they have TikTok has some type of issue with people in South Memphis? Because that's what it's starting to give. 4 videos. 4 videos. Live, live, love, name. I hadn't even watched that part yet. I was getting myself ready so that I can start the stream. So I haven't seen anything other than the beginning of court. I saw the juror's email. I saw that Detective Thorpe can't come back. I have to go back and watch it. So I'll probably, when this is over, I'll resume watching court from where it is. And then afterwards, I'm going to go back and watch the other testimony because I just need to update. I know that's right. I'll go back and watch it later. But yes, y'all, it's not me. So when you see videos upload late at night and it's talking about something that happened in the day, that's because it's just now uploading. So I don't know, but it's good, Dr. Chris. They wore the correctional officer out. Period, Sherilyn. What part of South Memphis you from? Yes, this is Ron Steele's argument to the Supreme Court. He is representing Blaylock in that first-degree murder charge that he and Lil Rod have. If he wins this appeal, then they're going to get a new trial. I'm not sure if Lil Rod will get it too, but Blaylock gets the new trial. I'm not sure how it works because I didn't know all of the details from the Supreme Court case, but I know Blaylock, if he gets it, he'll get a new trial. So we'll see what's going on. But y'all got me. Are you from Claiborne Homes? Okay. Y'all got me ready to watch court from today. I did see that there was a sheriff's deputy, and I saw they were going to play a video. But then I said, let me just start at the beginning of court, at least so I can see what happened with Thorpe, because I really wanted to know if Thorpe was going to be able to come and they were going to be able to go around her sanction, which I'm happy they weren't. So y'all, the state is in shambles. Okay. Yeah, the state. It's a 2-1. Okay. Thank you, Kara. So y'all, they worked him. Oh, okay, y'all. I am ready. I'm ready. I'm making shanks from items inside the jail. Oh, wait, y'all. Lucci was supposed to be in protective custody, y'all. Oh my God. He was supposed to be in protective custody, and that happened to him. Oh, baby, I can't wait to see it. I can't wait to see it. Y'all, I cannot wait. He started it. Y'all saying Lucci started whatever happened. So let me tell you this, because I didn't see that. Hold on, y'all. Let's see what he's talking about. What still says admission ceremony. Okay. Wow. Yo. Oh my God. Yes, we can, Destiny. Destiny, I got to see it. He was supposed to be in protective custody, y'all. Oh, they was asking how they got out. Lucci was the one who was supposed to be put up. Y'all, this is too much, but I'm going to tell you. Someone said that sometimes the jail, police officers, the state will do things to put you in harm's way. And it definitely sounds like they put that man in harm's way. How the hell is he supposed to be in protective custody and he gets stabbed while he's in jail? Because Shannon got stabbed too. I doubt he was in protective custody, but Shannon was stabbed as well. How does that happen? Lucci followed him. Oh my. Okay, I gotta watch it. It's y'all telling me too. The inmates can move doors. I love y'all so bad, but I can't stand y'all at the same time because not y'all got me ready to watch this video. Was our first and then let Lucci out. When Mike was supposed to be put up before Lucci was let out. Okay, y'all, let me go. Okay, I'm finna go back. Oh my God.
During today's session, we will hear arguments in two cases. In both of those cases, each side will have 20 minutes for argument. If the opening argument does not last for the full 20 minutes, the remaining time may be used for rebuttal. We remind counsel they're not required to use all of their time, as sometimes less time and shorter arguments are more effective. You will note, as in our courtroom, the courtroom clocks are located where you can see those. When the yellow light appears, we remind counsel you will have 5 minutes to complete your argument. When the bell sounds, we would respectfully ask you to wrap up your argument as your time has expired. With that, Madam Clerk, will you please call today's first case?
Yes, Your Honor. S24A 1303, Damone Blaylock versus the state. Brian Steele for appellant, Alex Burnick for appellate.
Let me go on mute.
Good morning, Mr. Steele. Good morning, Mr. Burnick. Once you get yourself settled, Mr. Steele, you may proceed when you're ready.
Good morning. May it please this honorable court, my name is Brian Steele, and I represent appellant. On May 24th of 2019, appellant was indicted for participation in criminal street gang activity, malice murder, 3 counts of felony murder, 3 counts of aggravated assault, criminal damage to property, possession of a firearm during the commission of a crime by the Fulton County Grand Jury. The appellant went to trial with other counsel, and the count 1, which is the gang count, was severed or bifurcated. So that did not go to this jury. On September 30th of 2021, appellant was convicted of all of the counts of the indictment that went to trial. He is currently serving life in prison plus 25 years, and that's all at record page 7 through 14 and 354 through 356. Appellant has raised 4 enumerations of error. The last one is cumulative error under State versus Lane. Unless this honorable court directs me otherwise, I'd like to discuss the first enumeration of error, which deals with a witness being sworn and on most of the questions invoking her Fifth Amendment right not to answer the question. The facts are very simple. They're tragic. There's loss of life here and destruction of lives throughout. It is 3 gentlemen are in a car. Not that it matters. The car was stolen that day in Cobb County. They drive to Fulton County. They come here because they're speaking with a woman named Miss Hartfield. Ms. Hartfield explains to the gentleman if they come to Atlanta area in Fulton County, they will be able to get high with girls and have sex. The 3 men come, they pull up. It is early morning hours, and Ms. Hartfield and another young lady named Miss Smith are in the car with the gentleman. Miss Smith exits the car purportedly to get the marijuana. Ms. Hartfield actually did that. Ms. Hartfield comes back a moment later, asks Ms. Smith to come with her. As soon as Ms. Hartfield and Ms. Smith were away from the car, gunfire erupted. The car was riddled with bullets. The front passenger was fatally wounded. The driver tried to leave. The car was disabled. The driver and the rear passenger flee. And Ms. Hartfield is on the phone later, and it's videoed. It was a FaceTime call, and it's videoed by a different person, a witness named Mr. Bell, and is being asked by one of the surviving witnesses, did you set us up? The law enforcement gets the information, and they find and take in that night Miss Smith. She tells law enforcement, I don't know what you're talking about. I have no idea what this is about. Eventually, after 2 hours, she is confronted by law enforcement. They're very sophisticated, very accomplished homicide detective with City of Atlanta. And she then implicates appellant, the co-indictee, and Ms. Smith. Ms. Smith tells law enforcement, I don't know what you're talking about. Pursuant to Instagram messages that the trial court allowed into evidence, it was identified as appellant and the co-indictee speaking with Ms. Hartfield, and Ms. Hartfield explained that Ms. Smith snitched, told appellant's name, gave Ms. Hartfield's name, and appellant responded, I knew that she's a rat, and what did she say about me? Those are not the exact quotes, but that's the way it came out.
But that sets up the facts for what is an IAC claim around her invoking her fifth. Is that right?
Yes.
Can you articulate for the court the nature of the IAC claim? And for me, I'm interested in the prejudice side of it as well.
Okay. So Ms. Hartfield is going to be a witness. She's in custody at the time of trial. She announces she has her own independent lawyer. Her lawyer announces to the trial court that her client will not be testifying. And she does that properly. Everybody agrees it's proper because Ms. Smith is potentially set up this murder. She was close to the murder. She's on the phone afterwards with the supposed killers, the co-indictee and appellant. She lies to law enforcement allegedly about she wasn't there.
Was there any indication that Ms. Hartfield was going to testify about anything?
She did testify to things that were not germane to appellant's trial. But yeah, she answered that she
What
knew.
about the threats? Those weren't germane? The fact that she said she was threatened to not talk, or maybe someone said they were going to kill her?
Yeah, so that came out that the victims, the living victims, that their friends, family, supporters, gang members, whomever, were threatening Ms. Hartfield because she supposedly set up the death of the deceased.
So counsel, let's contextualize what we're doing. There's no question, at least in my mind, that the procedure in the trial court, the best practices for a witness invoking the Fifth Amendment were not followed. I mean, the precedent sort of lays out, this is the best way to handle a witness who is going to invoke their Fifth Amendment rights. We don't really like that happening in front of the jury. That's not sort of the best practice of how to handle it, but it doesn't require that, right? In other words, the precedent that says this is sort of the best way to do it doesn't say it's the only way to do it.
This was pretty much the worst way to do it, but yes, I agree with you.
So because you're coming in through ineffective assistance of counsel, you have to demonstrate that no reasonable lawyer would have considered this to be beneficial to their case. And while I understand, but I was going to say it because you're bound by your prejudice arguments. Independent of that, your argument is, hey, look, there's not overwhelming evidence of guilt here. Assuming I don't accept that the other evidence that was coming in was pretty damning for Mr. Blaylock. I mean, you sort of got the sequence of he's there, he's identified as running and shooting at the scene, and then you have the after the fact. And I understand that it could be construed another way, but saying I knew that she was a rat, all those sorts of, that's pretty bad evidence. He's really sort of for the jury tough to hear those things. Why is it not possibly a reasonable strategy, something that a reasonable lawyer could do, to say, hey, watching this witness take the fifth over and over again when my strategy is create as much confusion and possible reasonable doubt? In other words, it might benefit my client. Why is that not a reason? Why could no reasonable lawyer have thought that?
For three reasons. First of all, this trial lawyer, who's a wonderful lawyer, and she's learning, she never tried a case like this at all. She tried.
But I'm not judging what she thought, right? It's an objective standard. It's not whether she had a good strategy. The question is whether any reasonable lawyer could have done what she did.
No reasonable lawyer would have done this. What happened was the prosecutor asked the following sets of questions that are germane. They're talking about February 23rd, 2019. Was Ms. Hartfield with Ms. Smith, the other person that we mentioned? Fifth Amendment. Was she in the area where the shooting occurred? Fifth Amendment. Was she with appellant that day? Fifth Amendment. Was she with the co-indictee that day? Fifth Amendment. Did she communicate with appellant on Instagram? Fifth Amendment. Did she arrange for the victims to get shot? Fifth Amendment. Did she enter the blue Charger, the car of the victim?
Why does that not
Fifth
just let the jury infer that it's her fault and not appellant's fault, and this shift blame away from appellant to her?
That never happened. The only question she did answer,
No, but why wasn't the jury authorized to infer that?
because that would be unreasonable.
Well,
She's invoking the Fifth Amendment. Did I interrupt you?
no, thank you. But I mean, it's to say it's unreasonable. I mean, one juror might think that's unreasonable. One juror might think it's reasonable. We let jurors make those kinds of inferences.
Wasn't the argument articulated that she was covering for herself and others?
No, I mean, that really never came. That's the prosecutor saying. The evidence, the argument was that there's not enough evidence to prove that appellant was there. That was her defense. And said, listen to these witnesses. The facts are not overwhelming, respectfully. Ms. Smith, who did identify appellant as a shooter, she gave total inconsistent statements. She was in the car and she was impeached thoroughly. The Instagram messages are what I explained. They're not so overwhelming to me. I mean, when you cross-examine, which you couldn't on this because Ms. Hartfield wouldn't allow the cross-examination, that was not that bad evidence. And nobody would agree that this is a good strategy. I don't believe no objective basis to believe that a reasonable lawyer would think, yes, let Ms. Smith handle the testimony and get confused. There's no confusion here. Ms. Smith did answer the questions on cross-examination by appellant's lawyer. Did she set up the victim? She said no. And did she direct appellant and co-indictee to do the shooting? She said no.
But you also said she's been impeached so many times, the jury would have been authorized to believe or disbelieve any of these answers, given how often she was impeached.
How was she impeached? She invoked the Fifth.
You said she was impeached.
That's Ms. Smith.
Oh, I'm sorry.
The Honorable Justice Bethel said, potentially this is overwhelming evidence. There's an eyewitness. That eyewitness is I wouldn't want to call that eyewitness.
Isn't it possible that the counsel was trying to throw out red herrings to possibly have the jury think, well, we don't know what happened or who was responsible?
Counsel didn't even respectfully know that she could object to this procedure.
She not only didn't object, she helped craft the instruction.
That's the worst part.
And but and I'm gonna let you respond to that. Back to the strategy and what a reasonable lawyer might do. Did I misunderstand that maybe Hartfield's counsel, the trial counsel, Blaylock's counsel at trial, in closing argued that this witness, Hartfield, was using the privilege to shield whomever she was protecting, and that she really set everything in motion and she was protecting the real killers whom she was trying to shield. I mean, was that the argument made by Blaylock's lawyer at trial relative to her testimony?
That's a closing argument after the trial is broken, and this is how it comes out. There's no reason to put up Ms. Hartfield and allow her to invoke the Fifth Amendment. The lawyer didn't know about it. The problem we have here, really, that's bad. I think that's bad. But you want to talk about reasonableness and objectively under the Strickland standard. How about the jury instruction? At the very end, the jurors are now deliberating, and they ask, how can we use this Fifth Amendment invocation? And with the help, non-objection, and consent of appellant's lawyer, the court said, and there's more to it, this is a transcript of volume 11, 1465, line 8 through the next page, line 1. the trial court said that our Constitution guarantees that individuals cannot be compelled by the government to provide incriminating information about herself, the so-called right to remain silent. When an individual takes the Fifth, she invokes the right and refuses to answer questions or provide information that might incriminate her about this case or other. This is the part that I'm stressing. Now, this concept factors into your fact-finding and ultimate decision, how this concept factors into your fact-finding and ultimate decision is for you to decide. And this court has explained over and over, we are going back decades, that when a witness invokes their Fifth Amendment, that cannot benefit or be to the detriment of any of the parties. That's why I have a problem with this. And that's why when it combined, you can't just look at it, to me, in isolation. That's why without knowing the law, you can prevent the witness from testifying and then couple that to tell the jurors, you can use this in your deliberations.
Well, that helps you on deficiency, but we still have the question of prejudice.
The prejudice, this, this court has seen more cases than I have ever seen. But I've tried a lot of cases. This is not an overwhelming evidence case, respectfully. I mean, you are the judge, you make better determinations, but to have an eyewitness that lies to the police immediately, that explains that she changes her story, even at trial, she gets impeached with different versions of her story. She's in a car where people are now dead and she doesn't get charged. These are factors jurors take into consideration.
Mr. Steele, I think I understand your position on the strength of the overall evidence. Can you articulate the particular harm of this sort of colloquy in stating the Fifth that you say sort of impacts the prejudice inquiry? Why was it so prejudicial, and why does that sort of tip the balance?
Because we know the jurors were interested in it. The jurors sent out a note during their deliberations asking how they can use it. They were given an erroneous instruction. And under our law, they should never have been allowed to use against appellant potentially the fact that were you with
And
appellant?
why was it likely that the way that this went down through the trial, that it would be used against the appellant rather than sort of in some other way?
It couldn't be any other way. The witness, Ms. Hartfield, said, I'm not involved in the shooting. I didn't direct the shooting. Were you with appellant? I'm not going to answer that question.
Well, while we still have a couple minutes left, could we pivot to another one of your enumerations? The second enumeration, the burden shifting and the comment on silence. I am troubled, particularly on the comment on silence aspect, but because it is brought through, and I intend to ask the state about that during their time, but because it's raised through the lens of ineffective assistance, again, that requires a showing of prejudice. What is the prejudice from the comments on silence, particularly when one of them, there was an objection made and the objection was sustained and the jury was told to disregard that one particular sentence?
Jury was told to disregard, I think it's 5 words of a sentence. They were not told to disregard that entire argument by the prosecution. Right. Telling a prosecutor, to me, as a reader, knowingly commenting on the accused right to remain silent is well beyond what we're doing here.
In terms of deficiency, I think that's a strong argument, and which is why I'm taking you straight to prejudice.
And to say to the jury, I want to know, I need to know, the quote is, if they were not committing the murder, where were they? And then if you read out the part that the trial court struck, if you disregard that, it reads like this. If they weren't committing the murders, where were they? They are both saying it wasn't. They weren't there. We didn't hear any evidence of it, obviously, but I would still like to hear that answer. And it's clear it's talking about where were they?
Well, the sentence before that, or the words before, we didn't hear any evidence of it, was preceded by, tell us where you were, implying that they had an obligation to not be silent, but rather defend where they were.
So I don't believe that the instruction was proper enough, go far enough, but your court always taught me that generally jurors who are sworn are bound to follow the court's instructions. And the court said, I'll sustain the objection. Tell us where they were should be disregarded. So I read it out. That's why I did that.
Do you, counsel, do you think that Lampley, where we said, quote, you may not have every question answered because the only person that can answer all of your questions is the defendant sitting there at the table, was permissible? Do we need to overrule Lampley for you to win on this point, or can you distinguish that? I mean, is Lampley right, I guess is one question, but can you distinguish from that comment?
Well, respectfully, I don't think Lampley's great writing from the court, respectfully. I mean, respect. But I don't think you need to overrule
It does happen.
Not often, but I don't think that it needs to be overruled, because in context, the prosecutor here was clearly going at the fact that appellant did not testify. The appellant did not put in this evidence. There is no way around it. The lawyer, the prosecutor, was so prepared on his objection the first time by saying, no, Your Honor, it's not objectionable because I prefaced it. I surrounded with, there's no burden of proof on the prosecution.
But Mr. Steele, there were objections here. So what is the ineffective assistance where you say, I mean, is there a piece of this that was not objected to that is the focus of this argument, or?
The only objection was burden shifting, and I thought this court taught that the objection should have been commenting on the silence. That's why I raised it. I don't believe that it is. There's an objection. I just have to be honest with everybody.
And so the ineffective assistance claim is not the lack of an objection, but an objection with the wrong explanation for it?
Your court teaches that you have to make a specific, proper objection. I believe, if I'm wrong, then that's me on habeas, but I believe that the objection should have been the comments on the right to remain silent.
Counsel, let me ask, if the court excluded, tell us where you were, outside of that statement, how is it wrong for the prosecution to say there's no evidence?
Not what the prosecutor said. Prosecutor said, I would still like to hear that answer. It is still going to the fact that the appellant did not make that claim.
But is that directly enough to win your argument?
I hope so. I will find out.
Good answer.
Mr. Steele, that's a good way to conclude. Thank you for your argument.
You so
Appreciate you. Thank you. Vernon, good morning.
If it may please the court, my name is Alex Bernick, and I represent the state of Georgia on behalf of the Fulton County District Attorney's Office. I'm gonna go ahead and jump in right into enumeration 1 here. That's one we spent most time on.
So if, with your apologies, could we pick up where we left off there?
Of course.
And help me understand why this comment on silence, which is you would agree that it's a different point than burden shifting.
Right.
Why that's not a problem to say, I would like to hear this answer. Why? You're going to tell me in a minute on prejudice that you had overwhelming evidence of guilt. Then why does a prosecutor need to stand up in front of a jury and play games with constitutional rights?
Well, I think this comes back to this court's, as I cited back in my brief to Ridley. Ridley states that where the defense.
Other than Lampley, none of the cases you cited apply to something like this. Ridley and Thompson, and I think it was Johnson or Jackson. They're all cases either about the defense's failure to offer other evidence. For example, defense lawyer says, all these other witnesses who didn't testify would have exonerated me. State stands up and says, you didn't even subpoena them. State offers lots of circumstantial evidence. Defense lawyer doesn't rebut the circumstantial evidence or explain it. Defense lawyer or prosecutor stands up and says, they didn't explain away that evidence. That's very different from the defendant didn't tell you something important. Evidence coming from the defendant as opposed to explained or argued by the defense lawyer is a very different thing when it comes to right to remain silent. In our case law, the only case that I see that gets close to that is Lampley. And the statement there was really in context more of a throwaway than a principal point that was repeated through multiple sentences.
I'll disagree with you on that one. I think when you look at the closing argument in total, you'll see that this is a comment about the defense attorney's inability to explain away or present evidence on their behalf. And as in Ridley,
In context, it's pretty clearly a comment on the defendant's failure to answer the question where he was.
well, I think when we go back to the second closing, that's where we come back when the prosecutor begins the second closing. He explicitly references the attorney's argument there. He explicitly references, did you hear in the attorney's argument that there was any failure to explain? It wasn't about the choice to testify. It wasn't about whether the defendant testified here. It was clearly throughout it, it was with expressed to the defense attorney's argument and failure to rebut the evidence, which is in Georgia law has been accepted that you can do. And
I know I sidetracked you on the enumeration too. If
Go
you
ahead.
want,
No,
you
no,
want
go
to do the
ahead.
Fifth Amendment thing, that's fine.
if you want, do you need me to address prejudice here?
We may come back to it. I mean, prejudice is going to be the same for all of the first three enumerations unless we get to cumulative. So if you want to talk about your evidence, you certainly can. But I think we're familiar with what the jury heard. Yeah.
I'll go back. I'll just go ahead and go to enumeration 1 then, with the text messages. Excuse me, text messages, got the wrong one. Fifth Amendment. This is clearly trial strategy here. It's clear trial strategy. It's a coherent trial strategy. You see it in opening. The defense attorney asked why the two women were not at the table, and that the defendants were scapegoats. They were hiding something. Closing argument. The attorney comes back around and says, Mariah Smith and Hartfield are the ones who set this in motion. Why are they not here? And then we come back to the motion of trial where she testifies and she says, part of my strategy is to put the blame on them, ask why they were not there, and argue that the privilege is being used as a shield for him or
But how does that map on to the jury instruction? Because the jury instruction then seems to undermine that to some extent.
I don't think it does. I think the jury instruction complements trial strategy here. It allows them to build in this inference that, and while inferences are not allowed, it does allow her to build and argue that.
So it was good because it allowed something that's not allowed?
It can be.
Inferences of her guilt are allowed.
Inferences of her guilt are allowed,
Yeah.
right.
But can you explain how that addition to the jury instruction is supposed to be understood by the jury consistent with the Constitution?
On its face, it's more likely that it's not consistent with the Constitution, but we're here in an ineffective assistance realm, and so with trial.
Are you conceding there was deficiency?
I'm not conceding because
Okay.
I
I
think,
mean, because I think if you're, I get what your point is. It's not, the question is not simply, was this jury instruction right?
Right.
But at the end of the day, if what you're saying is, no, actually, that would be really hard for a jury to understand consistent with the Constitution, then I think.
but erroneous jury instructions are not necessarily per se deficient performance.
They're not necessarily, but it can make it. I mean, it really then points us to prejudice.
Right.
So what is your best formulation of that argument, that there is none?
There is none. I think we go back to Horn on this case, and Horn is very similar, and that was a direct review case. Horn asked whether there was any evidence of material facts that were added from the leading questions. And it's very similar to cumulative evidence in a prejudice in an ineffective assistance of counsel. And here I would say there was no material facts that were added, either as to appellant's guilt. If you were going to add any facts, any obvious inferences that were made, it was that she was a co-conspirator, and that's obvious from the evidence that was already introduced and independently introduced of this. Also, we do have strong evidence that was noted by the trial court who was in the position to make that finding. They're the ones who saw the trial develop. They were the ones who also were able to just address credibility and weigh that evidence just as a juror would.
But counsel, how can you say that there was no inference that the appellant was guilty when she took the fifth on questions like, were you with him on that day? Do you know him? I mean, all those kinds of things where, I mean, wouldn't the inference, if the jury believes she was taking the fifth to hide something, she was hiding the fact that she knew him and that he was there at the scene on that day. So why is that why would that not be an inference of guilt against Blaylock?
Well, I think we come back also to her cross-examination testimony that she gave there. She denied setting them up. She denied directing Blaylock or Ryan to shoot them. And so between the inference that could be created, as you suggested, and
Well, trial counsel argued she was protecting the real killers.
Right.
Obviously, it wasn't Blaylock, somebody else.
Someone else. And honestly, she also took the fifth to saying that she had a gun that day, or she shot him. So you could also build that.
But is that a reasonable inference to draw? I mean, when the question is, were you with this defendant during the murder? And the answer is, I'm going to assert my Fifth Amendment right to avoid self-incrimination. No, I was not with him is not incriminating to her. The only answer that's possibly incriminating is yes, which then ties him. I mean, isn't that sort of by a wide margin the most reasonable inference to draw from that invocation?
I don't think so necessarily. I think it creates the gray area that she wanted to bring up. She wanted to hide the real killers. It's a gray area that she wanted to operate in, is to create this reasonable doubt, create that there's someone else out there that was in there. And I think she wanted to create that, and that ties into the trial strategy.
How does not answering the question of were you with this defendant during the murder doing that?
Well, it was, I think the question was, were you with the defendant that day, not necessarily during the murder? And so that day is broader than the murder, than the time
What
of the
else
murder.
could she, what else could be incriminating that happened that she wouldn't be able to answer about? Do you see what, like, it seems like if she's invoking,
Mhm.
then there's something she's worried about that's incriminating to her, which then leads to the inference that the presiding justice was suggesting.
Or could it be the inference of other prosecution activities that they had earlier in the day?
It could be a prosecution, other prosecution, the marijuana deal, the drug deal that she set up. Could be that.
Are those not part and parcel of what ultimately culminated in the murder?
They were, but not necessarily part of what was charged with the appellant.
But I mean, if that's all they had been involved with, and then there was a murder, you would have charged that as party to the crime, and we'd be here arguing about that. So, I mean, I don't see how that's really how that's potentially bringing in third parties through this inference. And the other problem is, if this was Jackson's sufficiency, we would say, well, it was a conceivable inference that could have been drawn, and we allowed juries to do that. But this isn't Jackson's sufficiency. This is Strickland prejudice, and we look to what inferences are reasonable and likely.
Well, Lawrence also says that it's obvious inferences there, and so I don't know if it's necessarily obvious that that Blaylock was with her during the time of the shooting. It could be reasonable to infer, but not necessarily obvious.
Seems like it's a pretty reasonable, unreasonable stretch to draw that inference. I don't disagree with the questioning from the presiding justice. My question is, though, did counsel argue at closing the third party inference that the jury was supposed to draw from the invocation?
No, she did not, and she just argued with respect to Hartfield was that, Mariah Smith and Hartfield clearly set this in motion. She focused more on Smith's testimony and the location of the bullets and ballistics.
Which makes the inference you rely on even more difficult.
I think
it's not reasonable. If it's reasonable trial strategy, you would have presumed that the lawyer would have argued it in closing.
She would have, but it ties into this argument here, this sentence here.
I mean, do we assess deficiency and prejudice in slices like that, or do we look at it in the context of the whole case? The question is not, could any reasonable lawyer have done this one discrete thing in the abstract? The question is, could any reasonable lawyer, and it is an objective standard, have done this thing in this particular context of the whole case, right?
Right.
Okay.
I think it's to the whole case, and we also see that this argument doesn't apply just to that they were lying, they were hiding. It doesn't apply just to Hartfield herself, it also applies to Mariah Smith. And so I think if you had it just applied to Hartfield herself, you'd have a bigger issue. But because it's Mariah Smith, you showed this trial strategy has been crafted about the whole case itself.
So I apologize, excuse me, if I missed this, but I'm not sure I've heard a prejudice argument from you that talks about, that assesses the strength of the evidence overall.
Okay.
Could you provide that argument?
Yes. Mariah Smith was eyewitness here. She identified appellant shooting into the vehicle. I think the most corroborating circumstantial evidence is that we have those text messages that were sent, I guess Instagram messages were sent shortly after Mariah Smith and Hartfield had been picked up by law enforcement, interviewed by them.
Were those Instagram messages admitted? I thought there were some problems.
They were admitted. And actually, they were raised on motion for new trial, and they were not raised here in the Supreme Court. But they were admitted of objection. And those Instagram messages talk about why else would Blaylock be interested in someone being picked up and snitching on him in a closely related time, and also knowing that she was a rat. So it's implied guilt there, implied.
I mean, that, so sort of by your own phrasing, you're admitting these are circumstantial pieces of evidence. Sometimes it's hard to get to overwhelming evidence by just circumstantial evidence. Is there anything else?
But you can. There's also the text messages that place Hartfield and Blaylock and Ryan at the scene close in time. We know that both Mitchell and Hartfield were texting between the two, and Mitchell and Uten's story, even though they didn't identify Blaylock, they largely corroborate her narrative of what occurred that night. Also,
And their description of the shooter is reasonably consistent with the physical appearance, although they couldn't identify anybody, right? So let me ask this. So basically you've got evidence that the four were together, the two men and the two women. They split up and the two women joined the three victims, for lack of, I mean, the three folks that were in the car when the shooting started. And then they moved to a new location. The women got out of the car in what appears to be a coordinated fashion, if we're taking the evidence in your way, and then shooting broke out. Right. And then after the shooting, there's this flurry of messages between the women and some of the victims and the women and the appellant, right?
Right.
And so when the appellant responds, I knew this person was a rat, is the only inference of that I was guilty, or could it be I was double crossed? There was somebody else and I've been set up.
well, I think the inference is that he was guilty is because Hartfield sent that to both Blaylock and Ryan. He didn't send it to anyone else. It was to them two specifically.
And did he ask afterwards, what did she say?
Yes, she did ask, what did she say? And so I think the obvious interest here is that we're still, and as I would put it, we're still in the concealment phase of the conspiracy here. And that she's asking about what happened. And this is closely short in time. There's no other evidence in the record of any other activities that could have incriminated him or them that happened after the shooting. And so the obvious inference here is that this related to Blaylock's admission of guilt to his co-conspirator. If there's no other questions, I'll address the third enumeration.
Sure.
Of the text messages. Here we have the trial court found that there's deficient performance in failing to find the text messages. There are two text messages that were sent by Bernard Mitchell to a person with the Instagram handle PFK Don, and largely they both say we shot back. And while there was deficient performance in failing to find, the trial court found that there was no prejudice from them. There was no evidence that they would necessarily use them, and also importantly, that they were cumulative other evidence that had already been, in my words, debunked by Detective Hogan. And I'll just go ahead and go to the cumulative here, is that Mariah Smith had already she told law enforcement during her interview, and that came out through Detective Hogan's testimony, that she had told them that Mitchell had shot back. And when that was presented, Detective Hogan said this did not make sense with the physical evidence at the scene. In order for it to shoot back, they were talking about the 9mm shell casings that were found at building, I believe, X, and the two that were found on top of the car. And when he testified, he said 9mm shoot, and when they eject, shell casings, they eject up and to the right. So for someone to shoot back at someone at that angle, the shell casings would have landed away from the vehicle. They would have not landed on
It,
top.
it is true that not all handguns eject. I mean, revolvers don't, right? I mean,
Right.
so the fact that you didn't find casings from a third gun doesn't mean there weren't a third gun, right?
Doesn't necessarily mean, and Mitchell and Uden both said they had guns, and Mitchell in particular said there's a 22. There's just no evidence of a 22 being fired there. And for the shell casings that were found, it was that Detective Hogan testified that a 22 does not shoot 9mm or 7.62 caliber bullets that were found at the scene.
Counsel, can you now address cumulative prejudice? Because I mean, I've heard you talk about 3 enumerations, and it seems like there may be deficiency with all of that, and you've gone to prejudice. So you've got prejudice from taking the fifth. You've got prejudice from commenting on silence. You've got prejudice apparently from admitting these text messages. How is that not cumulative enough to warrant a new trial?
I don't think these are cumulative enough because I don't think they actually impact the evidence that was given that supported the defendant's guilt here. None of them take out.
That's a tough argument.
It is a tough argument, but I don't believe that they pull out any of the pieces that would support defendant's guilt. It's not that you're removing, let's say, the Instagram messages that were circumstantial.
But all the evidence that you offered us to support the strength of the conviction was also circumstantial. So we're
Right.
pulling out, circumstantial building blocks and a circumstantial pyramid.
But they're not necessarily being pulled out here. The as we talked about, the text messages, they were largely debunked anyway. The jury had already heard it's cumulative, so you're not pulling out any evidence there. The failure to testify, there's no evidence that what he would have testified. There's nothing that's being debunked there.
But the prejudice is the fact that you alluded that he should have testified, and he would have not been able to provide any evidence other than he was at the scene of the crime. I mean that's the prejudice there.
But there's enough.
Is it possible that that prejudice is also compounded in this context by the Fifth Amendment issue, because the jury has heard instructions, not with respect to his not testifying, but about inferences they can draw about somebody who doesn't testify?
No, I don't think that's necessarily done. I think here is with the inferences that were made, they were with reasonable trial strategy, and that they supported the trial counsel's strategy here, that there was another person there. And so I don't think it benefits him at all. And I don't think it attacks that to any extent. If there are no further questions, I just ask you to confirm these convictions and sit down. Thank you.
Thank you, counsel. Thank you, counsel, for both sides for the fine argument. We'll try to have your decision as soon as possible. Thank you.
Hold on, y'all. Let me stop this. So what did y'all think? Okay. So let's address, let me see. There were 3 things that they talked about so that people can kind of understand like Brian's arguments and what they were saying to the state. When it is your right to remain silent. So bringing up the fact that the defendants remained silent is an issue. That's one of the things the Supreme Court was talking about. And when they talked about the Constitution, the fact that he says, I can kind of see how it violated their constitutional rights, but basically but I don't want y'all to use that against us. It is their right. It is their right to remain silent. If I choose to do that, and it shouldn't be held against you in the court of law. We all know this. We all know when you're Mirandized, they tell you these things, right? BBL Diego is insane. 7, goodbye. They tell you these things, right? So for them to, in their closing arguments, bring up the fact that they remain silent is a problem. In some paperwork I saw about this appeal, I saw that the lawyer, Lil Rod, allegedly had an alibi that she didn't even bring into court. So that's that. Miss Ma'am pleading the fifth. Why is that an issue? Because one, y'all see how big of an issue it was when you plead the fifth in front of the jury, right? And the Brian Steele is saying the lady didn't know she could object to it. She didn't know that she could have, the lawyer, he said she's new, but Brian said respectfully, she's never tried a case like this before. So she didn't know that she could object to that. And that young lady pled the fifth on almost every single question they asked her. And so what they were saying, you know, why wouldn't they infer that her pleading the fifth is like she's hiding something, or maybe she's trying to protect him? Because that's what I would think. Well, why doesn't she want to tell us? She's hiding something. Yes, Jasmine, that's what I saw. I'm not a lawyer, but shared it. So yeah, so pleading the fifth was absolutely an issue, because what they're saying is they could probably infer that she's trying to protect Blaylock, right? So that is the jury instructions. Thank you. Very, very weird. And then the text messages. Y'all saw them damn text messages in the case? When y'all saw the text messages, what did it do for you? Because for me, it confirmed what everybody was saying. In my mind, I wasn't piecing the story right, so I didn't think setup. But when the next day, when D. Williams got up there, and then we saw those text messages, I said, "Oh damn, this is a setup," and they have confirmed it in the messages. They didn't show those messages, didn't provide them, because they told the story. Hold on, was trying to protect herself. Exactly. So they told the story. Then I wondered, why did those boys leave their friend in the car? Well, the car was shot up. The car broke down. They had to get out and run. Now I understand why Mariah said we saw two people get from the car. Okay. The appeal was today. YouTube user, the appeal was today. And yes, Dee, I have been of the mind that maybe this was some sort of initiation, but I'm also of the mind Mariah didn't see the boys do anything. Maybe it was planned, and if so, in the new trial, that may come out. But I have been of the mind, get a new trial, right? The police did not properly investigate this case. Get a new trial. If the boys go to jail after that, they go to jail, because at the end of the day, someone died, okay? But I can say I don't think their first trial was a fair trial. Does that make sense, y'all? If they go to jail, they go to jail. No, the decision won't be today, guys. So if they did this, bye. But hold all of them accountable if that's the case. But here's the thing. His lawyers, Lil Rod's lawyers, are going to have to provide some doubt. If they're going to not charge those girls, the point in this case is separating Lil Rod from these girls. Does he have an alibi? Get him his alibi, because they didn't see anything. But do they know who did it because it was planned? That's a different story. So that is a different story, y'all. Do they know who did it because it was planned? And if that comes out, Mariah's going to jail as well. At this point, why would they give her immunity? But if they give her immunity to really talk about this being planned, because she has stayed the course that she doesn't know why this happened, all of this. So this could be hurtful to Mariah as well. And Brazy. Brazy could turn now. Y'all know Brazy's in jail. Brazy could turn. Brazy could get her sentence reduced, because they want Lil Rod and Blaylock now. Now it's looking scary. So Brazy could turn. Robo, you've seen Fulton County give lots of liars immunity. But hey, Brazy could turn on them, y'all. Brazy's in jail and probably doesn't want to do those 15 years. Brazy could turn. My friend turned on me. If it means I can get out, I can turn on her. I'm just saying, y'all, this is going to be interesting. How Candace, Brian Steele is representing Blaylock. Yes, that someone in the chat said this is like a 2-for-1. So if it's a new trial, they both get it. Dee, let's talk about it. Let's not be crazy. Holmes was shot in the back of the head. It has been my belief, because it didn't go through the headrest, he was in the front passenger seat. What if when the girl started running, what if it made him turn his head this way and to see why? Because remember, Mariah and Brazy ran out from the back passenger side. What if he turned his head? The shots came from like the driver's side. And when he turned his head to see why they ran, that's how he got hit. It's just so many things. So new trial may be coming. New trial may be coming. It's going to be really, really interesting to see how they handle Lioness, Mariah, and Brazy. Really interesting. So what I'm going to do, guys, I thank y'all for streaming. I'm going to stop this stream so that this can be a separate thing. And I'm just going to start a new one. And I'm going to continue to watch trial. So if you guys would like to watch the trial with me, as soon as I end this stream, I'm starting a new one so that we can pick up on the YSL trial. But thank y'all for tuning in, and give me like 5 minutes to set it up. And then I'm going to start the YSL trial because I'm going to continue to watch trial from there. But thank y'all. See y'all in a minute.